Can a country capture a foreign leader from another country and put them on trial in their own country? The answer is yes, according to the US justice system. And the reason why? A little something called the Ker-Frisbie doctrine. It's a US legal principle that's now at the center of global outrage after Washington captured Venezuelan President Nicolas Maduro and flew him to New York to face US federal charges. Now, as we all know, on January 3, US forces launched an operation in Caracas, detaining Maduro and his wife and transferred them to US custody. Under international law, that would violate a country's sovereignty and the diplomatic immunity of a sitting president. So how does Washington justify it? By relying on Ker-Frisbie. The doctrine comes from a series of US Supreme Court rulings that say this: US courts can try a defendant no matter how they were brought into custody. It doesn't matter whether someone was extradited politely or taken by force. If they are in front of a US judge, the trial goes ahead. See, the doctrine was used in 1989 when US forces invaded Panama and captured General Manuel Noriega. Despite international condemnation, US courts ruled that the way Noriega was seized did not invalidate the charges against him. But analysts say Maduro's case adds another controversial layer: recognition. See, the US has refused to recognize Maduro as Venezuela's legitimate president since he was re-elected in 2018, calling the election fraudulent. Now, by treating him as a criminal suspect rather than the head of state, Washington argues he's not entitled to presidential immunity under international law. See, for years, US prosecutors have accused Maduro of running a so-called narco-terror network, alleging links between his government, drug trafficking, and armed groups. The US Justice Department's case against him came with indictments, sanctions, and even a public bounty that eventually reached $50 million. US officials have a fancy name for foreign interventions like its latest operation in Venezuela. They're called extraordinary renditions, a term critics say sanitizes cross-border abductions carried out without formal extradition. Now, stay with me. From the perspective of international law experts, forcibly entering another country without consent is a breach of international law, as per the UN Charter. But here's where things get complicated. See, the US is not party to a number of key international legal frameworks, including the Vienna Convention. Critics argue this allows Washington to act outside rules it expects other countries to follow. Washington's actions have culminated in a division of legal opinions regarding Maduro's capture.
I remain deeply concerned that rules of international law have not been respected with regard to the 3 January military action. The Charter enshrines the prohibition of the threat or use of force against the territorial integrity or political independence of any state.
But supporters argue Washington's actions are about accountability, not aggression.
This was not an invasion. We didn't occupy a country. This was an arrest operation. This was a law enforcement operation. He was arrested on the ground in Venezuela by FBI agents. The Department of War went in, they hit anything that was a threat to the agents that were going in to arrest him, and they hit anything that was the threat on the way out.
So while Ker-Frisbie may allow Maduro's trial to proceed in Manhattan, the legality of how he got there remains fiercely disputed. And that leaves us with a much bigger question. If recognition can be withdrawn and borders crossed to enforce domestic law, what kind of precedent has the US just set for the rest of the world?